Welcome to Grow Fast, Grow Smart, the PI Playbook by Accelerator, the podcast exclusively designed to help personal injury law firms reach their full potential and serve their clients better. Let's jump in.
Hello, everybody. This is Stephen DeBosier with Dudley DeBosier. We're here for the PI Playbook podcast, and this is presented by the law firm Accelerator as well as Dudley DeBosier. And today we got a friend of mine named Jon Hollan, and he's going to up in Louisville, Kentucky, and Lexington, Kentucky, right? You really stay in Lexington, right?
That's right, yeah. So our offices are Louisville and Lexington, and really handle cases all over the state of Kentucky, though.
Well, fantastic. Tell us a little bit about yourself. I know you work for the great guy, Sam Aguilar, up there in Kentucky. I know he spends most of his time in Louisville, and you're in Lexington, but tell us a little bit about what you're doing.
Yeah, so I've been with Sam for about 11 years now. Started when I was a law clerk, finishing up at U of L, and then I've been an attorney for actually next month will be 10 years. Kind of wild today, Steve, the day that we're recording 11 years ago today, back in 2013 would have been my first day with the firm. Kentucky boy, born and bred. A lot of people are familiar with, or at least have heard of my hometown, Hazard, Kentucky, in southeast Kentucky. So I grew up in the mountains. A lot of people familiar with Dukes of Hazzard, so I hear that a lot. Undergraduate, did that here in Kentucky at Georgetown, played on the golf team, went to U of L for law school. And, I'm one of those kind of the unique or somewhat weird. I always knew I was going to be a lawyer. It was never, I never really had a backup plan. I did a little refereeing at one point, but, I knew I wasn't anywhere near good enough to keep playing golf for a living. So always knew I was going to be a lawyer. Always knew I was going to be in a courtroom to some extent. I didn't know transactional, criminal, PI, what exactly it was going to be. But started working with Sam about 11 years ago and really quickly fell in love with representing injured people and in particular the litigation and the trial aspect of the work.
It's some fun stuff, isn't it? So I call it a short career because I've been doing it for 30 years. So you've done it 10 years. You've done a lot of stuff that I was still trying to dream about after 10 years. So you've tried some cases, right?
Yeah. I was, I've been pretty fortunate in that regard. I think the first case that I participated on a trial team on as an attorney was two or 3 months out of law school, up until I was really hell-bent for whatever reason on trying 10 cases before my 30th birthday. Didn't quite get to do that. Got it up to around 9. COVID hit, that slowed things down for a couple of years. Back in 2019, I believe it was, Sam and I tried a case, and it was actually a police pursuit case. To our knowledge, I was the first attorney under the age of 30 in Kentucky to get a 7-figure verdict. So that was pretty special. And, they all haven't been winners. I mean, that's a lot of them have been cases where, hey, I'll give it a try. And still to this day, it's just, we've done a lot of great things. But the trial work, it's what keeps them going.
I tell everybody October of 2013, so now it's 11 years ago, is when I decided I was only going to try the cases I want to try, not the one that the insurance companies wanted me to try. And those of you that have done it long enough know exactly what I mean. And if you don't know exactly what I mean, then you're going to find out, which is don't let them decide what cases you're going to try. So today we're going to talk about two things that are dear to Jon's heart. I know this because Jon and I had some time to visit. And one of them is visuals or demonstrative evidence. And the other one is themes for cases. So I'm going to let you decide, Jon, which one you want to cover first?
Yeah, I think we should start with the visuals because they do kind of lead hand in hand. But I can tell you at least the way my brain works and the way I practice, I really start thinking about the visuals, and we'll even have our team starting to put some kind of visuals together into our files, often within the first day or certainly the first week we take a case.
And so it's a big deal. And lawyers, we think we're so damn smart. You're not. Listen what I'm telling you. You're not as smart as you think you are. I'm not talking to you, Jon. I'm talking about our audience. And this is what's important, is that people don't realize statistically the human being can retain about 20 to 22% of what's told to them. All right. That's why you hear show and tell, right? Show and tell is a big deal. Is it right?
Yeah, absolutely. And, it doesn't matter what type of case we're trying. whether it's a lower speed or not a lot of property damage type case in a car crash, or a premises case or a truck crash, no matter how catastrophic it is from the very beginning, and certainly at a jury trial, you're going to see us use a lot of images, not just things you can see, but, things you can touch, things you can feel. We want to give that to the jury because it truly is, the cliche, a picture's worth 1,000 words. In trial work, it's just so important, especially in today's world. It's TikTok, it's Instagram, it's YouTube. We consume media differently. We learn things differently. So being able to not only tell the story, but show the story, if you want to win, it has to be done.
It's a non-negotiable in our firm. You have to make sure you know what you're going to do. What are you going to show the jury? When John and I talked last week, I looked around my office and I was showing him this morning. I have a shackle from a case I was working on a forklift case where they dropped something on somebody's head. I have these things all around my office, and spine models, and they're just everywhere in my office because holy goodness! Isn't this the greatest one? You can show the herniated disc and it pops out. Where is it? Oh yeah, see that right there? It pops out. Oh yeah.
Yeah. Steve, we got to put a link to this thing in the show notes because it's $20 on Amazon, and I've not gone to a trial or a doctor deposition in the last 7 or 8 years since I got this on a disc injury case without having it in my hands.
And it's just things like that are so important that once you allow a juror to post this to the jury, publish it to the jury and let them take a look at it, let them put their hands on it to see what you're looking at instead of just having some doctor up on the stand. One of the things we do when it comes to doctors and visuals is I have this device here. I call this Ed because we have a full skeleton called Fred. Ed is just the neck down. But we'll, let the doctor lay that on the privacy wall for the jury and show right in front of them what kind of surgery he's doing. And that's something that'll help that jury remember things that they won't otherwise remember. So.
Yeah, that's 100% true. And one of the things I speak a lot, and then I also get consulted a lot. I do pretty much all of our firm's referral work as far as cases being referred to us by other lawyers, and we've got a lot of great referral partners, a lot of friends of mine. And Steve, one of the questions I'll get is, well, you go and you put on these shows, or you'll take this deposition, and you've got the resources to do this. And one of the things I tell other folks is, I don't just present these things, or you can do it like we do it. Yes, there are some times where I'm spending more than $100,000 on a case, but there's sometimes I might spend $5 or $10 and, get some of the exhibits I've spent the least amount of money on over the years have just driven the other side crazy. And it's just creativity. And that's, I'm not the most creative person, but I think when you spend a lot of time and you think about these things, you can really think of good ways to present a case that don't have to cost you or your firm or your client all that much money to present what you're trying to do.
But you know what it takes, right? You tell me if I'm right or wrong on this, John. You got to take some time away from the world and just think. You can't we're in the practice of law, so we're always doing stuff. You got to just stop and go, what would really matter to 12 people if they saw this, right? There's a good friend of mine, Aaron Broussard, who wrote one of the chapters in Trying to Find the Book, and when Nick Riley's latest book of opening statements and voir dire. And Aaron Broussard, a year before, he's got 100 exhibits or demonstrative evidence, and poster boards, all kinds of stuff. And he's thinking it through long in advance. And for a lot of us, we have a tendency to work on things that are important but not urgent, right? That's the hardest category to work on. We're always working on what's important and urgent at the same time. But man, just knowing if I do this now, it's going to make my life a lot better down the road. So, those are things that are all important to us. I got a guest walking in here, James Pelche, who's one of my partners. We're doing a podcast in here, James.
Hey, guys.
Yeah.
So tell us about some of the things you've used as demonstrative evidence in.
Yeah, so I've got a few of the interesting ones on my desk here. And Steve, just to kind of preface this, one of the things that I noticed when I started doing this, so our firm, we don't do any medical malpractice work, but that doesn't mean that doctors want to talk to us any more than they do any other lawyers. Doctors and medical groups, they don't want to deal with lawyers. I think they find us annoying. I think they're scared. And so oftentimes, getting our pre-deposition conferences or really getting opinions, it's hard to break the ice. And I think, unfortunately, as medicine has gone more corporate, that just continues to be a bigger problem. And I say that because what I've learned is that, rather than just rushing through a deposition or give me the chart, I'm a very busy man or woman. I've got to be out of here for my next clinic at 1:00. If I start bringing the toys in and if I show the doctor, hey, this is what I'm going to ask you about today. And if you could, I would really like for you to educate myself, the other lawyers, and then the jury that's going to be watching this video on what exactly we're talking about. That changes the game. It takes it from just a chart in black and white to them remembering the human being and then them getting to say, I'm going to be the teacher. I am going to use my knowledge and I'm going to teach the jury. So I have one, and Steve, that everyone in my firm knows that this brain, it was a huge case. So you can see this was a traumatic brain injury case, but I've got this, there's writing on here. I don't know if the camera's picking it up. It's black, it was with a Sharpie, but that's actually from a neurosurgeon. So that was our client's treating neurosurgeon in this case who took the brain, just a model I purchased on Amazon. There was an exhibit sticker here, but it fell off at some point. And
that had to have been awfully expensive, John. How much did that brain cost you on Amazon?
This wasn't even a high end brain. This was a lower end brain, and I think it might have been $30 or $40.
Okay. So when you say a lower end brain, are you talking about my brain now, John? Is that what this?
It's a cheaper brain. I'll let you interpret that however you want. But yeah, this was used. It was a frontal lobe injury. So the doctor divided the brain up, marked F for frontal lobe. And then during that same case, there was a drill. So there had to be, there was pressure on the brain. So we had a drill we used in this case too. So, and it's, it goes from a doctor explaining a very, a procedure that they do a lot, a procedure that on paper, and to this doctor, I've done thousands of these over the years, versus him holding this in one hand, dissecting it up, and using a power drill to explain to a jury how they drilled through our client's skull, relieved that brain pressure, and saved her life.
And so I think everybody picked up on the power of that, but let's be clear. You can talk about drilling into the brain, and that sounds horrific, but nothing sounds as horrific as the sound of that drill, thinking about going into your skull, right? That's where the power is, right?
Yeah, and that was the very question, because I spent, you're not going to see this today, but I actually spent quite a bit of money on some medical illustrations specific to this case and different boards. We went through several different iterations of the board we were going to use at trial with the neurosurgeon, and they just kept coming back flat. We would do focus groups, and it didn't look that good. It was too complicated. It was too many words, too many images. And it was actually a legal assistant that was working on like a new shelf or something that had came into our office. And I heard that drill and that's where it is. I don't need these boards. Give me our office drill. I'll take that to the doctor. And that's how we're going to explain this.
Oh yeah. 30 years ago, I handled a case against a dentist, my only medical malpractice case. The guy dropped a drill into this lady's eye while he took a phone call from his girlfriend that his wife didn't know about. That had some great facts, but just having that drill, they couldn't pay that case fast enough when they saw that drill come into that courtroom. Just the thought of that, what people think about when they go to the dentist, or they don't know what brain surgery is like. They think it's some kind of special drill. Hell no, man, it sounds just like that, right?
Yeah, and frankly, I think any surgery is going to be. We picture doctors, orthopedics in particular, a lot of our orthopedics, I'm sure you've deposed them and the type, there'll be bigger, stronger people. And we think of surgery, as being this little, knitting something back together. Oh, yeah. It's power tools. It's ripping things out of place. And another good source, I don't know if I included them in any of the stuff I sent you, but maybe not for getting it into evidence, but, demonstrative evidence doesn't have to be admissible. So again, we're the YouTube, we're the TikTok world. Any surgery you want to show to a jury, or you want a doctor to, rather than a doctor just explaining this, oh, this is what we do, this is my op note, show them the YouTube video or go on Google and show them the images. The other side's going to go crazy. That's fine. Let them go crazy. But you can easily get the doctor to say, no, I'll watch, that's a 30-second clip. That is 100% the procedure we performed here. And when you have time, and again, it's getting more difficult to talk with doctors, but we'll take the video or the illustrations or the brain or whatever it is, even if I can't get an hour before the depot or when I'm doing the disclosure, I'll go and I'll try and get there, doc, let me talk to you for 3 minutes, 5 minutes before we talk or before we start this deposition. And sometimes I've been told, no, John, that's not it, but here's the one you really want to look at. Pull out their iPhone, send me the YouTube link. We're in business 15 minutes later.
There you go. And, most doctors really appreciate that when they stop and think about it. Just what are we going to talk about? Where are the problems with this case? And you lay it all out to them. They're much happier as a general rule. So let's talk about some other demonstrative evidence that you used. Oh, by the way, I want to touch on one thing, because you just said this, which is very important, which is demonstrative evidence may not necessarily go to the jury, and it's different standard of how it goes in and how the jury gets to see it. But my suggestion to you is, after doing this for 30 years and watching judges make mistakes, have what I call a pocket brief, where you're showing them this is exactly what the law is with respect to demonstrative evidence. So when there is a problem, you can give it to the judge and say, Judge, I want to be clear. This is what the law is on this, and this is why I can do it. If the judge has the law right in front of him, is much less chance of him messing that up. So think about it, try it. I don't know if you've done that, John, but having that ready to go is a powerful tool for most judges.
Yeah, we do it. We have, that's in our trial binder, every single case. And one more tip on that, we're in Kentucky, so we're not known as, the most cutting edge as far as, legal trends or some of our case law. But we have great law here in Kentucky. And then in our, as it relates to trial practice, if there's not something, on evidence or demonstratives, there's so much good federal law in your circuit, in your state. And I just can't tell attorneys enough, even if it's not the direct state court opinion that you're looking for, look at the federal law. State court judges in particular, for the most part, in my experience, love having federal law to rely on when they can. And especially as some of this more cutting edge stuff, technology, some of these higher end illustrations that we're going to talk about, there's case law out there you can find and lawyers that'll help you with the briefing.
Cool. Well, let's look at some other stuff you sent me. You want to look at some of this stuff?
Yeah, I was going to show you one more I had here in front of me, and this is one I don't know if y'all have done this yet. I've done this on a couple cases now, and honestly, it just keeps getting more affordable. But this is an actual. So this is my client, and yeah, this one still has the. So this is from my client's treating neurosurgeon. I believe it was a lumbar fusion. It's got the hardware in here. So this was actually taken from our client's post-operative X-ray or MRI. I can't remember which exactly. And then a 3D printer put this together based on that image. I think it was less than $500 at the time, maybe $400 or $500, something like that. And I think it's gotten even more affordable now. So again, this was introduced as evidence. We settled this case just before trial. But technology is just changing so quickly, and taking and whether it's an orthopedic injury, a spinal injury, whatever, you can take the images, work with your doctors, and you can get you can't show them your client, they can see it on a television, but this is something I can hand to a jury. They can touch that cervical or lumbar hardware and touch that with their hands, feel the real spine. It's just it's a game changer as far as the way you present this case. Seeing it, hearing it, touching it, feeling it. We want all the above if we can.
Yeah, that's fantastic. So tell me, the audience may be wondering, who's the vendor you used for that?
So that one was actually, and I think here in Kentucky, we've got, I want to say it's not High Impact. I work with High Impact on a lot of my It's Highfield and Open is one of the big MRI companies in Kentucky. And I think they're a national vendor for these MRI and imaging centers. But I believe, Steve, from the way we did it on this case, any imaging facility and probably a hospital would probably be tougher. But if you've got an independent imaging facility, they actually have access to say, Steve, you call tomorrow and say, I would like a copy of my client's September 3rd MRI, 3D printed, and they order that themselves, and it's really affordable.
Oh, fantastic. So, Jon, I wanted to thank you, man. It's a great, great introduction into what we talked about, visuals for trial. It's really good stuff. We're going to come back and we're going to do another episode where Jon can share his thoughts on case framing, case themes to make your case even better.
Yeah, Steve, looking forward to it. As everyone will hear, everything, it all ties together. So A plus B to C, so I look forward to talking about how we use our visuals, our demonstratives, with the themes in mind, and how we bring all this together, whether it's for a case settlement or taking it to a jury, and how everything plays along with one another.
Good deal.
That's all for today's episode of Grow Fast, Grow Smart, the PI Playbook by Accelerator. Be sure to subscribe for more tips and tricks on growing your law firm the smart way.